a major development to report in the Fulton County RICO criminal case against Donald Trump, and those co-defendants who remain who have not pled guilty. Judge Scott McAfee is granting Donald Trump and the co-defendants special demur, which is a motion to dismiss on 6 of the counts in the felony RICO indictment. We'll go through what those counts are. It's count 2, it's count 5, it's count 6, it's count 23, it's count 28, and it is count 38 are the ones that we have a graphic right there. These various counts relate to the issue of solicitation of a violation of oath of a public officer, whether it was telling the governor, the secretary of state, or others to violate their oath. Judge McAfee states that there are not sufficient facts that were put in the indictment by Fani Willis and the district attorney's team. Popok, why don't you discuss more about this order, and why don't you and I discuss a little bit about our thoughts on it?
Yeah, and where we think it goes from here. Look, we were waiting for an order from Judge McAfee today. We just thought it was going to be the one on Fani Willis, whether she was going to be kept on the case or disqualified along with Nathan Wade. And in a way, we might be able to read, you, Ben, you and me, a little bit of the tea leaves here. Good news is the two major headlines here, I think for our audience, before we dive into the molecular level, is the indictment overall and all 161 of its overt acts, bad conduct that form the basis of the indictment survived the motions to dismiss or the special demurs, as you framed it in Georgia procedural law. That's headline number one. So in other words, he did not dismiss the indictment. We were afraid because that is an ask in the a motion to disqualify Fani Willis and Nathan Wade. They also asked for the indictment to be dismissed. And if he was going to do that in an order later today or later this week, along with her disqualification decision, he would not have picked and chosen through a number of elements here. So I think that's a good sign for justice, the fact the indictment has survived. It is not unusual for certain elements of an indictment to be dismissed. And in this case, the ones that he did mostly are against Giuliani and others, but there are two at the heart of it that go against Donald Trump. And yes, not the overt act, not the allegation that Donald Trump and Mark Meadows picked up the phone and tried to make the phone call on January 2nd after the election to Brad Raffensperger, Gene Sperling, and others, and get them to find the 11,758 votes that he needed to overcome the election results. The phone call is in and is still a part of the racketeering conspiracy allegations against Donald Trump. But there was two standalone counts based on that phone call for separate crimes. And it's some of the counts that you just referenced there towards the end, 23, 28, and 38, I think, although you'll clean up for me when you get it back. The counts themselves, the judge found that as a matter of his interpretation of Georgia law, there's not enough information provided to Trump and the others, Mark Meadows particularly, about what oath of office the constitutional officers were being asked to violate. Well, there's only two that they take. They take one in particular, one to uphold the Georgia Constitution and the U.S. Constitution. So Fani in her indictment, despite the fact that it goes on for 98 pages and contains 161 overt acts, 41 original indicting counts from a grand jury. I mean, we all have on Legal AF our dog-eared copies of this original indictment. Even though she got that out of and returned from the grand jury, he's troubled the judge that as it relates to the oath that is allegedly violated, that not enough information has been provided to the defense to allow them to fashion a defense. Now, you and I will disagree with that here on the midweek edition of Legal AF and on the weekend edition. But the third headline for me is we will disagree with the decision and the way he's ruled on it. But he knows that there are two ways to cure this problem and to re-indict and get these standalone counts against Donald Trump back up and running. Again, the overt acts are part of the criminal conspiracy. They're still alive in the indictment about the phone call in particular, because I know that's the one everybody loves because it's direct evidence of Donald Trump's criminal conduct as alleged in the indictment. But why don't you want to do footnote 8? Because footnote 8 for me is the entire ball of wax about where the judge has now left it in Fani Willis's court to do the next thing to try to save these counts. Are you self-conscious about your smile due to stains? Are your teeth aging you? Popular food and drinks are known to stain teeth. Beverages like coffee and wine stain them over time. So what can you do to brighten your smile? Well, you should give Smile Actives a try. Smile Actives is safe, effective, easy to use, and will keep you smiling proudly. As you probably know because of all the videos we do, I'm a big coffee drinker, and over time I noticed my teeth lost some of their brightness that I was used to seeing. 97% of Smile Actives users in a clinical trial reported up to 6 shades whiter on average, all within 30 days. Simply add Smile Actives Pro Whitening Gel to your regular toothpaste. It's been formulated with PolyClean technology to boost stain removal and deliver active whitening ingredients into teeth's grooves and crannies to get better whitening. Smile Actives makes a teeth whitening gel that can simply be added to your toothpaste every time you brush your teeth. So no change in your routine, no extra time, and no more messy strips, trays, or lights. People will start commenting on your whiter, brighter smile in just days. Smile Actives is the whitening boost your favorite toothpaste needs to give you the smile you deserve. Visit smileactives.com/legalaf today to receive a special buy one, get one free offer with auto delivery plus free shipping and handling. That's smileactives.com/legalaf. Terms and conditions apply. See site for details.
Yeah, let's just take a look, just at the technical counts for precision. If you pull up Salty, that front page right there where it says the first page of this indictment, you see the counts against Donald Trump. So 1, 5, 9, 11, 13, 15, 17, 19, 27 to 29, 38 to 39. Then when you look at the highlights, go back to the first page there. You see the ones that have been stricken right there, and you see the ones that relate to Donald Trump. So, that's what's at issue here when you have both Trump and kind of the counts relating to the other co-defendants. Right, with the underlying claim, the assertion, the crime was this solicitation of these lawmakers, the governor, the secretary of state, to violate their oath of office. One of the first arguments Trump and the co-defendants made is that Fani Willis, the district attorney's office, never said what the oath was. Judge McAfee says, no, it's fine. They said what the oath was. But then what Judge McAfee says is that even if the relevant oaths are apparent as a matter of law, the defendants contend that the counts do not detail the exact terms of the oaths that are alleged to be violated. The state first responds that defendants are only charged with solicitation, not the violation of the oath of office, and argues that the, quote, great weight of authority has never required charging language to reach beyond the elements of solicitation itself. But then Judge McAfee cites a Georgia case called the Sanders case, which says you have to then provide the elements of the predicate felony here. And then they say that Fulton County District Attorney Fani Willis didn't do that. You go on and it says, Judge McAfee writes, and here's what you were pointing out, Popok, the court's concern is less that the state has failed to allege sufficient conduct of the defendants. In fact, it has alleged in abundance. However, the lack of detail concerning an essential legal element is, in the undersigned opinion, referring to the judge, fatal. As written, these 6 counts contain all the essential elements of the crimes, but fail to allege sufficient detail regarding the nature of their commission. And what he's referring to there is the actual, in terms of what was being solicited to be violated in specific details. And I don't know, when you're talking about overthrowing the results of a free and fair election, my view, Michael Popok, is it's pretty clear on its face what it was referring to, and what more do you need to say? If there's an oath to defend and protect the Constitution and you do the opposite, it seems that was alleged to me. Going to the footnote that you mentioned, here's footnote 8. It says, this does not mean the entire indictment is dismissed. The state may also seek a re-indictment supplementing these 6 counts. Even if the statute of limitation has expired, the state receives a 6-month extension from the date of this order to resubmit the case to a grand jury. Then it goes on to say, alternatively, the state may request a certificate of immediate review pursuant to the Georgia law, which the court would likely grant due to the lack of precedential authority here. So kind of certifying it for an immediate review and appeal. So that's the lay of the land right now. To your point, Popok, all other aspects of this indictment remain. It deals with those counts, and some of those counts relate to Trump, some of them relate to other people. I disagree with the order, but it's not like this case is dismissed. I'll give you the
I
final
agree.
word.
That's why I wanted to lead with the headlines to sort of manage expectations here. Indictments, counts of indictments, especially ones that go on for 41 counts, it's not surprising or unusual to lose a count or two. It's one of the reasons that I don't want to call it over indicting, because that would raise the blood pressure of our colleague Karen Friedman Kniffelow, former prosecutor. But they indict a lot in case they lose a count or two. The headlines that we'll see in the media, which is what we want to explain better here on Legal AF, is that, oh crap, the whole phone call is the direct connective tissue between Donald Trump himself, because there's only about a handful of places where Donald Trump picked up the phone and made phone calls, as opposed to having his henchmen do it at his request or behest. He made phone calls to Arizona. He made phone calls to Wisconsin, and he made phone calls to Georgia. And we always liked it as observers of legal and political news and analysis, because it is one of the clearest and most and easiest bit of evidence to present to a jury to link Donald Trump back to the entire conspiracy. He himself is on a recorded phone call making that. That overt act stays in, and it will support the racketeering, influence, and corrupt organization RICO count that is really the foundation of the entire complaint. But I'm sure Fani Willis is not going to just say, well, I lost 6, a couple against Giuliani, a couple against Meadows, and a couple against Trump, and let it stand. The judge, knowing that, as you said, has a safety valve, a circuit breaker in his footnote 8, in which he gives her those 2 choices: re-indict, and you have 6 months to do it. So it'll be a superseding indictment where she cleans this up. And if you don't like that, Fani, I'll certify you now to take an immediate appeal up to the Georgia court, the appellate court that's required. Reading the tea leaves, to kind of end my piece here for this, reading the tea leaves, the indictment is still on solid foundational footing. For now, Fani Willis, subject to his order on a motion to disqualify, remains. He did not dismiss the indictment. He only took away parts of it, which indicate to me that at least a major component of what Mike Roman, Donald Trump, and the others have been trying to do in trying to rake Fani Willis over the coals about her after-hour extracurricular dating life was to get the indictment dismissed, and to get rid of Fani Willis. Now we'll see how this indicates whether he is going to, and we'll probably, he said 2 weeks, Friday is the end of 2 weeks. We'll know better maybe by the time, Ben, you and I record on Saturday for the end of the week edition of Legal AF. We'll know what that means. Reading the tea leaves, I think it's neutral. For me, it's neutral. I'm not sure he's signaled yet. I don't think Fani can take this and go, I'm in, I'm going to win the motion to disqualify. But I also think there's cold comfort here for those defendants like Trump that thought they were going to get rid of the indictment. They're not. One open question for you, Ben, and maybe you know this. Are we now done with the special demurrers? Are there any else that are pending, or is this now wrap up all of the motions to dismiss against the indictment in one package?
If Fulton County District Attorney Fani Willis re-brings these charges, there would obviously be the right to bring special demurrers again based on these counts.
But are there any others still in the tank? or this is
I'm not sure if there's any pending, but Trump still has a lot of procedural moves that he can utilize to try to get this case dismissed. So it's nowhere near saying that this is smooth sailing for Trump.
Including immunity. I mean, whether it applies or not, he is now, as you've noted in a very good hot take you did, he's using whatever he can get from the federal side and on the immunity decision that's going to be up for an April 25th oral argument and decision making and the ballot ruling in his favor, and trying to bring it to various courts to throw that monkey wrench in.
Well, we will keep everybody posted. Hit subscribe. Make sure you subscribe to the Legal AF podcast as well, wherever podcasts are available. And thanks for watching, and have a great day.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.